Hello, everyone, and welcome to One Civil Law, and I hope you're having a great day. For today's stream, we turn our attention to the ongoing case of Jennifer Crumbley. You'll recall Jennifer Crumbley. She is the mother of Ethan Crumbley, who did a minor school bang at Oxford School, and himself was charged as an adult and convicted and sentenced to life in prison. So, the guy who pulled the trigger has been charged, convicted, sentenced, and all those things, as you would expect. Now, somewhat challengingly, or somewhat differently, the parents were also charged as a result of this, which was really, really odd legally. And we've commented about that. It really was odd because he was charged as an adult. These were independent voluntary acts that seemed to break the chain of causation. And there didn't seem to be an affirmative duty that seemed to be violated in this context. So I had many legal doubts as to whether or not this was a valid conviction because of those things. And we've already seen this basis for liability. We'll call it vicarious liability, I suppose, because that's the closest thing that it would be, right? I'm guilty because you're guilty. Vicarious liability. And so this idea of vicarious liability in a criminal context where you normally wouldn't have it, there's no conspiracy, there's no agreement, we're not Confederates. So it's a very odd form of vicarious liability, but we've already seen this extended in other states and in other contexts. So it's a very, very odd thing. In any event, the Crumbley, or in this case, Miss Crumbley, more specifically, Jennifer Crumbley, has motioned to have her trial reversed by the trial court. So we're still inside the trial court. This is not, strictly speaking, an appeal yet. This is a motion to the trial court, but we have a basis for believing that this is the same grounds that an eventual appeal would be based on, because basically we're basically highlighting all the grounds we're likely to appeal on. So we can see that this is likely to be their legal basis when they actually get to the Court of Appeals. So for the moment, we're still in the trial court with defendant Jennifer Crumbley's motion for judgment of acquittal and or for a new trial and request for an evidentiary hearing. Please find us not guilty. Please give us a new trial. Please give us an evidentiary hearing. Okay, cool. Let's see if we can do all those things. So what is our basis for doing that? Let's read on. On February the 6th of 2024, a jury found defendant Jennifer Crumbley guilty on 4 counts of involuntary manslaughter from a shooting that occurred on November the 30th of 2021 at the Oxford High School. Critically, for me, Miss Crumbley's son, Ethan, who was charged as an adult, pled guilty to the murders and ultimately was sentenced to life imprisonment without the possibility of parole. So the person who pulled the trigger has been held accountable pursuant to law. That's a good thing. But the Crumbley parents, it's a little bit more suspect. The prosecution proceeded on 2 separate theories of criminal liability for involuntary manslaughter as to the parents. That Mrs. Crumbley acted grossly negligently in storing a firearm and ammunition so as to allow her mild child to access the gun, which doesn't really make sense completely, to be quite honest, because how that gets you all the way to the shooting is a bit unclear. Or alternatively, that she was grossly negligent in failing to control her minor child so as to prevent him from intentionally harming others, which also doesn't quite make sense in this context. At trial, the prosecution offered the testimony of 2 school officers, Sean Hopkins, a counselor at Oxford High, and Nick Ejak, the dean of students, the principal of the school. Hopkins and Ejak were the last 2 school officials to interact with the shooter and his parents hours before the shooting took place at a parent-teacher conference, essentially. Relative Colptastic says, if you have a problem with charging on this case, you should also have a problem with extending liability of J. Hatch with respect to Beata's unaliving. I do have problems with that. I have massive problems with J. Hatch's liability with respect to Beata, the mother's unaliving. I don't think that legally makes any sense either. I think that's some legal bullshit. And I think that Florida is trying to create some new law when it comes to holding John Hopkins responsible for the death of Maya's mother. Their liability for Maya, fair enough. She's a patient. They have an actual duty. They actually have a duty to Maya. She's a patient in their hospital. They do have a duty to her by contract and by profession. But their duty to Maya's mother is deeply legally questionable. So I have significant reservations for liability when it comes to Maya's mother, and we've expressed that many, many times. So yeah, but of course, whatever concerns I have when it comes to J. Hatch's liability, when it comes to Maya's mother, whatever concerns those are still even greater when it comes to the Crumbleys. They're still even greater yet when it comes to the Crumbleys, because in J. Hatch, we're just trying to get money. It's only civil liability, people. It's only civil liability. So I have massive problems with it, but it's only civil. With the Crumbleys, it's criminal. So my concerns go from this is bullshit to this is bullshit that now involves some constitutional problems because of its criminal nature. So yes, we at least on this channel, we have significant concerns as to both. We have significant concerns as to both. Relative to the prosecution's two new alternative theories of criminal liability for involuntary manslaughter, the court instructed the jury that it's not necessary that you all agree as to which theory, as long as it's proven that you all agree the prosecution proved at least one of the theories beyond a reasonable doubt. On the second day of deliberations, the jury returned a guilty verdict on each of the 4 counts. They sure did. After the trial concluded, it came to light that the prosecution had entered into a proffer agreement, which is basically, please tell us the things, and we promise not to use the things you say against you. This is also sometimes called Queen for a Day, and it sometimes has some other names, but basically this is a formal process. You get it in writing, as one does, but it's a thing you can do, right? So it's not just the police, making some vague promises. This is, we're gonna get it in writing, people. You come in, you spill your guts, and we won't use what you say against you. So that's sometimes called a proffer agreement, sometimes called Queen for a Day. It has other names, but that's what it is. Great. And that's definitely something you're gonna want to get in writing in every possible way. So it came after the trial concluded, however, critically after the trial, it came to light that the prosecution entered into one of these proffer agreements with the witnesses. Well, that's really interesting. That's really interesting. Oh, okay. They had a proffer agreement you didn't tell the defense about. That sounds potentially suspect. As expressly set forth in the agreements, the purpose of the proffer was as follows: to receive truthful information from the clients, in this case, the school officials, including information about possible criminal activity by your client, the school officials, and others, and to evaluate your client's credibility, the school officials' credibility, as a source of information and potential witnesses. In return, this office will consider your clients, the school officials' statements in deciding how to resolve this investigation as it relates to your client and any charges pending against you by your client being prosecuted. So we will use this information to help us guide our agreement. And then there's some other things that we're going to say in there that says we won't use what you say against you. So we may still prosecute you. So it's not an immunity agreement. It's not an immunity agreement. It's narrower than an immunity agreement. It's basically a just this session though. It's just the tip of immunity agreements. It basically immunizes you from anything you say in this room during this day. If you say it any other time, if you say it in any other way, if we find any other evidence against you, you're host. We can't use anything you say to us within the confines of these 4 walls that occur within the next 5 hours, that kind of deal, right? So it's a very if you like to think of it as an immunity agreement, it's a very, very narrow one. But it's basically, we won't use anything you say against you that you say today. If you say it tomorrow, maybe. Anyway, so that's what they're talking about. Despite the defense counsel's formal written discovery demand, neither of these profit agreements nor the required statements nor the recorded statements were ever provided to the defense. Well, that sounds potentially suspect. On March the 20th of 2024, the prosecutor issued a press release indicating that it had received multiple requests for 2 proffer agreements provided to Nick E. Jack and Sean Hopkins, and further stated, giving ongoing speculation surrounding the proffer agreements and interest of transparency, the office is releasing the agreements. Oh, so they do exist. Oh, okay. We just didn't tell the defense about it. Ms. Crumbley now moves for this court for a judgment of acquittal, or in the alternative, a new trial based on the following. Defendant is entitled to judgment of acquittal based on discovery violations. Defendant is entitled to a new discovery based on prosecution's deliberate suppression of impeachment evidence, the proffer agreement, which might suggest a motive. Yeah. Defendant's right of due process and fair trial were violated by the prosecution's assertion of inconsistent theories of culpability. Defendant owed no legal duty to the victims of the shooting, such that they could be held criminally responsible. That's sort of where I get off the train, although that issue seems to have already been resolved by the Court of Appeals, incidentally. That issue's already gone to the Court of Appeals and back. And the Court of Appeals was like, yeah, we're okay with it. And I read their decision, and their decision sucked. The Court of Appeals decision sucked. Its reasoning left a lot to be desired. So, but they're not going to get any relief from that issue here. And they're not going to get any relief on that issue from the Court of Appeals. Maybe they'll get relief on that issue from the Supreme Court of the state. But it's going to be a hot minute. But of course, they have to preserve the issue. They have to preserve the issue so the Supreme Court of the state might be able to consider it someday. That defendant's constitutional rights were violated by the court instruction the jury could convict defendant in absence of unanimous agreement, at least as to the theory, and defendants and the ineffective assistance of counsel. Fun. For the reasons that follow, the court should grant Ms. Crumbley's motion and enter a judgment of acquittal, or in the alternative, a new trial. All right. The court should grant defendant's motion of acquittal based on prosecution suppression of the proffered agreements with 2 key witnesses. Michigan law recognizes the court's power to dismiss a defendant criminal charges based on discovery and or Brady violations. We saw that, for example, in the Alec Baldwin case. When you mess around with discovery, it can create problems. If granting a continuance would not serve to protect interests, only then should the trial court utilize more severe remedies. More recently, our Court of Appeals has affirmed the remedy of dismissal based on discovery committed by the prosecution. The Causey case makes clear a defendant need not succeed in proving a Brady violation before seeking the remedy of dismissal based on failure to overcome exculpatory evidence. So although Brady would be nice, it's not necessarily required. If they fail to turn over exculpatory information, but Brady isn't necessarily implicated for whatever reason, that's okay. This state has your back anyway. The state can always grant more rights. So they don't necessarily need to determine it violates Brady if they want to give you relief. They can give you relief for any reason they want, basically. They have to give you relief for Brady, but they can give you relief beyond that, so that's fine. The prosecution was duty bound under the law to produce not only the proffer agreement it entered with these witnesses, but also their recorded interview. The prosecution's duty under the law was expressly triggered when the defendant made a formal written request for discovery. The relevant law provides as follows. Upon request, the prosecution must provide each defendant any exculpatory information known to the prosecuting attorney and any plea agreement, grant of immunity, or other agreement for testimony in connection with the case. The relevant law also requires the production of any recorded statement, including electronic statements. Yeah. In a press release issued on March 2024, the prosecution asserted erroneously they have no duty to produce proffers because the agreements do not confer immunity, which is correct. They don't contain immunity. That is, they're a different concept. The prosecution's assertion, however, is belied by the plain language of the rule, which requires the production of any other agreement for testimony in connection with the case. Whether or not the prosecution proffer agreements conveyed immunity is beside the point. The fact remains the prosecution entered what can be characterized as a cooperation agreement. Okay? Under the relevant law, the prosecution has an express duty to produce any agreement for testimony in connection with the case. The prosecution failed to comply with the duty under these rules. The relevant rule confers broad discretion on the court as to the appropriate remedy to impose where the prosecution violates its obligation, including the entry of such other order as it deems just. So the court has broad discretion to fix the problem by whatever means they feel are required. Relying on this rule, the Court of Appeals in Causey made clear one such remedy is dismissal. So that is something the court can do. In considering whether dismissal of the criminal charges is warranted for discovery violations, including the suppression of evidence, the trial court must balance the interests of the court, the public, and the parties in light of relevant circumstances, including reasons for noncompliance. If granting a continuance would not serve to protect above interests, then only should trial courts utilize more severe remedies. In certain instances, like those present in other cases, a continuance before or during trial may be the more appropriate remedy to address a late disclosure. But as here, the damage caused by suppression and withholding of the cooperation agreement cannot be done or cured by at least a continuance because the trial's already happened. Hence, the court should grant the judgment of acquittal. As the law has made clear, the court has an interest in protecting and promoting the constitutional rights of a defendant to a fair and impartial trial. The prosecution already has sidestepped that interest by withholding from the defense favorable impeachment evidence. Hence, a continuation does nothing to protect the interests of the court. A continuation of what? Trial's over, man. The same is true as to the public interest, which is best served by enforcing constitutional rights and imposing a penalty upon the prosecution for violation of those rights. The prosecution, on the other hand, is the party responsible for violating the interests of both the court and the public by its deliberate withholding of favorable impeachment evidence. Certainly, the prosecution cannot expect to get a do-over after violating its ethical and constitutional duty. The public and the defendant, the appropriate remedy is the judgment of acquittal. Well, that's asking for a lot, but you might as well go big or go home. Apart from the duty imposed by the rule, the prosecution also has a duty to disclose to the defense any evidence it possesses that's material and favorable to the defense, citing Brady. The prosecution's duty under Brady has been extended to include evidence that could be used to impeach, citing Giglio. The failure to disclose impeachment evidence of consideration given in exchange for prosecution testimony, in view of Kyles and in view of Banks. Failure to disclose impeachment evidence indicating the witness is a government informant, citing Weary versus Kane. Failure to disclose 3 lines of impeachment evidence undermining 2 key witnesses. A new trial is required under Brady-Giglio, where the undisclosed evidence creates a reasonable probability of a different outcome. The question is not whether the defendant would be more likely than not to have received a different verdict, but whether in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence. The Sixth Circuit, which is notorious for habeas, issuance, has granted relief in numerous cases when the prosecution failed to disclose cooperation agreements with the prosecution witnesses. Yeah, that sounds like something the Sixth Circuit would do. The Sixth Circuit seems to do that kind of thing a lot. Citing Thomas versus Westbrook, relief granted where the state failed to disclose consideration given to one witness for their testimony. Citing Harris, granting relief to the defendant where the state failed to disclose considerations given to a key witness. Citing Mathis versus Bogus, granting relief where the state failed to disclose key impeachment evidence. Citing Schletwitz versus United States. In addition to these federal precedents, Michigan law has long recognized the duty imposed on the prosecution to disclose both favorable and impeachment evidence, citing People v. Akins, holding it's incumbent on the prosecution and trial judge to disclose to the jury any cooperation agreement conferring immunity or leniency. Whether or not that's what this is, I suppose someone will have to decide. Citing People v. Grissom, reversing the trial court's decision denying defendant's motion for relief from judgment based on newly discovered impeachment evidence, citing People v. Cross. A prosecution is required to disclose upon request any plea agreement, grant of immunity, or other agreement for testimony with the case. And, they did get testimony as a result of this, at least for their proffer they did. So that rule seems like it could be applying. Under Michigan law, the following three components establish a true Brady violation: that the prosecution suppressed the evidence is favorable to the accused, and the evidence is material. Whether under federal or state law, the test for reversal for Brady asks whether the suppressed evidence might have affected the outcome of the trial. As such, the court must now consider whether the suppressed proffered evidence was both favorable and material. They are both. The proffered agreements could have been used by the defense to vigorously cross-examine and impeach both witnesses, insofar as those witnesses provided key inculpatory testimony against Ms. Crumbley. Had the defense counsel had the proffer agreements, they could have brought to the jury's attention these witnesses had a motive, bias, and personal interest in helping the prosecution secure the conviction. Well, at least in so much as they'd like to not be charged. Fair enough. The witnesses were in the proverbial hot seat, hoping to avoid criminal prosecution for their acts and omissions. By cooperating with the prosecution, these witnesses were hoping to avoid prosecution such that they had a bias, motive, and personal interest to testify in a manner so as to shift responsibility towards Mrs. Crumbley and away from themselves. Further, the prosecution suggested in its press release there was never an implicit or explicit promise of leniency or favoritism of any kind. Such an assertion is contradicted by the express terms of the agreement. In fact, the proffer agreement expressly provides that in return for cooperating and providing truthful information, including information about possible criminal activity by you and others, this office will consider your client's statements in determining how to resolve the investigation as it relates to your client. Which, is that an implicit or explicit promise of leniency or favoritism? I don't know that it is. But, fair for the defense on trying. The proffered agreements further provide this office will not offer any proffer statement made by you or your client in this office's case in chief in any criminal prosecution of your client. In other words, anything you say during this particular session will not be used against you. Today only. Anything you say in this room will not be used against you. For the prosecution now claim there's never any implicit or explicit promise of leniency or favoritism is simply disingenuous at best or deliberately misleading at worst. As the Court of Appeals aptly noted, it is axiomatic that the credibility of the witness is an issue of the utmost importance in every case. It is also axiomatic that evidence of a witness's bias or interest in a case is highly relevant to culpability or credibility. Due to the undeniable relevance of the evidence of a witness's motivation for testifying, the prosecution must, upon request of the defense, disclose to the jury any other agreement for testimony in connection with the case. The court has held the defendant is entitled to have the jury consider any fact which might have influenced a witness's testimony. The court further elaborated the disclosure requirement may be considered satisfied where the jury is made well aware of such facts by means of a thorough and probing cross-examination by the defense. In this case, a thorough and probing cross-examination of these witnesses was hampered by the prosecution's suppression of proffered agreements such that the jury was deprived of key evidence regarding the witness's motive to testify against Crumbley. Having deprived the jury of such material evidence resulting in the denial of Crumbley's constitutional right to a due process and fair trial. And then they cite a case, at least from the District Court of Kansas, holding explicitly that defendants are entitled to plea agreements and proffer letters, at least in the District Court of Kansas. So it seems like they might not have law explicitly on point from their jurisdiction because we're citing Kansas. So it seems like they're trying to expand the law to include things that maybe this court has not yet held are explicitly required. But, fair enough. That's what they cite, the District Court of Kansas. On this point, the jury heard neither witness told the Crumbleys during their meetings that they had to remove the son from the school despite their purported mental health concerns. For example, one witness testified that the drawing gave me a lot of concerns about self-harm. The witness also testified that it was professional judgment that it was better for the shooter to be around peers and people who are with his age than at home alone. Another witness, on the other hand, testified he would have searched the school backpack if there had been any type of indication the school was going to threaten to harm anyone. Thank you, Mad962, for becoming an uncivilian. We do appreciate everyone who joins the channel and makes the channel possible with their continuing financial support. Thank you very much for hitting that beautiful, beautiful join button. Thank you, Tony P, for the 10 gift memberships earlier. Thank you, Ann Bella Feinstein, for the 10 gift memberships earlier. Thank you, Alan Parker, for the 20 gift memberships earlier. And thank you, Mr. IFS, for being a member for 19 months. All your support is, of course, appreciated. Given the inherent conflict between the witnesses' testimony, the jury had to decide who, if anyone, to believe, as far as whether the shooter posed a foreseeable risk of harm to himself or others. The importance of such testimony was more obvious given the charge that Miss Crumbley failed to control her minor child, and the prosecution offered testimony about what Miss Crumbley could have or should have done once she was summoned to the school. Finding itself unhappy with the witness's testimony, the prosecutor on redirect sought to shore up its case by eliciting additional testimony more favorable to the prosecution. For example, one witness was asked if he would respond differently if he had known the shooter had sent some text messages to his mom 8 months before the shooting about what he believed were abnormal concerns at home. To those questions, the witness responded that had he known, he would have handled the meeting differently. Putting aside the incredulous nature of Hopkins' testimony on redirect, the jury should have been made aware that Hopkins had a bias, motive, and personal interest. That is, to avoid prosecution, to help the prosecution by attempting to shift blame away from himself and onto Mrs. Crumbley. A comprehensive post-shooting investigation report prepared by Guidepost Solutions lays bare the culpability of both the witnesses. According to the Guidepost report, individuals at every level of the district, including staff, failed to provide a safe and secure environment. The point of highlighting these investigative findings is not to prove criminal responsibility of the witnesses. Rather, the findings merely demonstrate why the witnesses were offered proffer agreements in the first place, because they had potential criminal exposure. To the extent the witnesses testified so as to shift blames away from themselves and onto the parents, the jury should have been made aware of these agreements so they could more accurately and fully assess their credibility. Additionally, the Guidepost report repeatedly refers to an emergency operations protocol that dictated several specific steps that school officials were to take when presented with the threat. These emergency operation protocols are required by law. While the defense was never provided with a copy of Oxford's emergency operation protocol, it appears the prosecution had the document, which is supposed to detail how a threat to the school and a shooter should be handled. The post-trial discovery of these proffer agreements and secret conditions surrounding them raised many questions. Why did the witnesses need protection in the first place? Well, as to that, I can answer that question. I would be scared shitless about my own liability. Are you kidding me? Comparing the witnesses' failure to comply with the EOPs and failures identified by the report makes it clear the parents were held accountable for the wrongdoing of the school's employee. Well, then you kind of answered your own question right there. Why they need protection? Because they have potential liability. Upon information and belief, the EOPs called for the school employees specifically to take precise actions, such as asking an alleged suspect student if they had access to a weapon. Instead of letting the defense know it felt squarely on school officials to ask these questions directly to the student, the prosecution argued repeatedly that Crumbley should have been the one to ask the questions. All in all, the prosecution took advantage of the fact defense was not made aware of the proffer and protection offered to the witnesses, and therefore was able to blame Crumbley by failures of the school employees, specifically acts the school employees were required to handle pursuant to the EOP. On this point, it should be noted the court provided the jury with preliminary instructions to consider whether the witnesses had any bias or prejudice or any personal interest in how the case is decided. Have there been promises, threats, suggestion, or other influences that affect how the witness testifies? In general, does the witness have any specific reason to tell the truth or any special reason to lie? As the Michigan Supreme Court has explained, one of the elementary principles of cross-examination is that the party having right to cross-examine has the right to draw out from the witnesses and lay before the jury anything tending to affect the credibility of a witness. Had the jury been made aware of these proffer agreements, the court could have weighed differently the credibility of these witnesses. For these reasons, the court should enter a judgment of acquittal or alternatively grant a new matter of trial. Well, at least on my superficial reading, I'm not sure it falls squarely within any of the rules that they have cited with respect to this state. There's some authority from other states that says proffer agreements have to be included, but proffer agreements are not a promise of immunity, and they're not even a promise of better treatment. They're simply a we will consider it, whatever the hell that means. It's not really a specific promise. So but the statement might be. So the proffer agreement, I'm not so sure about. The statement itself, though, that was obtained might be disclosing. So, yeah, but it seems like they have a dearth of state-specific law on this point about the proffer. They're just trying to use more generalized principles to apply to the proffer. So, I don't think they're going to get any relief from the trial court. I'm sure these issues have been raised. Well, maybe not because they were disclosed late. But I don't think they're going to get any relief from the trial court. Maybe you might get somewhere with the Court of Appeals, but I wouldn't bank on it. All right. As to the prosecution, denied defendants' right to due process by asserting inconsistent theories. That the prosecution charged the shooter as an adult, but at the same time charging the defendant for failure to control minor child. Yeah, that is a bit of a problem. How do you charge the person as an adult and at the same time say they failed to control their minor child? It's like, is the child an adult or not? You know, can you have it both ways at the same time? I don't know, man. I don't know. That does seem like a bit problematic. The court should grant judgment on acquittal based on violations of Crumbley's due process rights caused by the prosecution's assertion of inconsistent theories of criminal liability arising from the same event. Although, to be fair, depending on what state they're in, and depending on that might itself not be a problem. In the federal government, you'd have no problem with this. It'd be mutually inconsistent pleading. And you can do that. The federal government explicitly allows for it. So you can have mutually inconsistent pleading, and you can have mutually inconsistent verdicts. So I can absolutely, in the federal system, turn around on one day and say you're an adult, and then the other day turn around and say you're a minor, depending on what I need to do that day. So in the federal government, I would be allowed to have my cake and eat it too. Whether or not this state allows for that, is a whole nother set of problems. But the federal government, I think, would be fine. The child's not an adult. They tried him as an adult. Yeah, I mean, I get that, but I'm still back to is there really a difference between those two things? I mean, I presume that you think the answer is yes, but I'm not so sure. Yes, he's not an adult. They tried him as an adult. It's okay, but is there really a difference between those two things? Are those different things? I don't know. Can you treat him as an adult on one occasion and as a minor as another occasion? I don't know, man. Can you do both those things? I don't know. Yes, there is. Well, thanks for resolving that, Michael. Thanks for resolving that right up. I'm glad that we have the answer to that question. Man, those are two different things. Boy, oh boy, that takes a lot off of my mind. Well, that concludes our legal analysis today because Michael has answered the question. Those are completely different things. And because they're completely different things, this entire argument makes no logical sense. Because they're different things, this argument makes absolutely no sense. So the fact that they charge him as an adult and the fact he's a minor child has absolutely nothing in problem with them whatsoever. There's absolutely no conflict, so we can blow past that entire argument. That saves me a lot of time. All right, moving on to the next argument. Miss Crumbley is entitled to judgment of acquittal because she owed no legal duty to the victims of her son's criminal acts. In the absence of any such duty, she cannot be held criminally responsible for involuntary manslaughter. Okay, let's give that a shot. Because Crumbley owed no legal duty to the victims in this case, she cannot be held criminally responsible for involuntary manslaughter under Michigan law, such that the court should enter a judgment of acquittal. While the penalties for manslaughter are governed by statute, the elements of such offense derive from the common law. Under common law, a charge of involuntary manslaughter based on omission on performance of a legal duty comprises the following elements: legal duty, capacity, means, and ability to perform duty, willful neglect or refusal to perform duty, and result of a death as an immediate and direct consequence of the people's failure to act. The prosecution's theory of liability against Crumbley was based on two theories. Defendant was grossly negligent in storing a firearm and its ammunition so as to allow the firearm and ammunition by, well, a minor child, because we resolved that issue. Or alternatively, the defendant was grossly negligent in failing to perform a legal duty, that the failure to exercise reasonable control of the minor child so as to prevent him from intentionally harming others. As such, the viability of the prosecution's case rests on whether the Crumbleys owed a legal duty to the victims of the shooting, which, seems reasonable enough to me. The prosecution has thrice confirmed its position that she was proceeding under theory that Crumbley had a legal duty to the victims of the shooting. First, during closing arguments, the prosecutor recognized the prosecution had to prove that the Crumbley had a legal duty to the victims. And again, during her closing rebuttal, the prosecution says, I have to prove she had a legal duty to take care and protect the other children in that school. Additionally, during the shooter's Miller hearing, the prosecution stated that Miss Crumbley had an obligation to students who died, and their gross negligence resulted in those students' death. The prosecution asserted that Miss Crumbley owed a duty to the victims. The shooting was wrong as a matter of law. The question of whether a duty exists for the court to decide is a matter of law. Duty is essentially a question of whether the relationship between an actor and injured person gives rise to any legal obligation on the actor's part for the benefit of the injured parties. And deciding whether Miss Crumbley owes a legal duty to which the predicate liability for involuntary manslaughter, it's first necessary to determine whether the acts or omissions constitutes misfeasance or nonfeasance. Michigan courts have distinguished active misconduct causing personal injury, misfeasance, and passive action or the failure to protect others from harm, nonfeasance. Based on the plain language of the charging document, the prosecution's theory of liability is based on nonfeasance, that is, failure to act. Generally, with respect to nonfeasance, there's no legal duty that obligates a person to aid or protect another. The only exception to this general rule is where a special relationship exists between the persons. An individual has no duty to protect another from criminal acts of a third party in the absence of a special relationship between the defendant and the plaintiff or defendant and the third party. The rationale underlying the rule is absent given the special relationship. A person has no legal duty to protect another from the criminal acts of a third party is rooted in the fact that criminal activity, by its deviant nature, is normally unforeseeable. Examples of special relationships recognized under Michigan law include landlord-tenant, proprietor-patron, employer-employee, residential inviter-invitee, psychiatrist-patient, and doctor-patient. The Court of Appeals described the rationale behind imposing a legal duty to act in certain special relationships is based on the element of control. In a special relationship, one person entrusts themselves to the control and protection of another, with consequent loss of control to protect themselves. The duty to protect is imposed upon the person in control because it is in the best position to provide a place of safety. Thus, the determination whether a duty-imposing special relationship exists in a particular case involves the determination whether the plaintiff entrusted himself to the control and protection of the defendant with consequent loss of control to protect himself. Based on these controlling precedents, Ms. Crumbley owes no legal duty to the victims of the shooting. I wouldn't think so. Where would her duty arise from? There are no facts from which to find any of the victims entrusted themselves to the control and protection of the Crumbleys. To the contrary, Crumbley had no connection whatsoever with the victim. In the absence of facts from which to find Ms. Crumbley owed a legal duty, there's no duty, which I would have agreed with, but the Court of Appeals already seems to have ruled on this issue and said there is somehow, some way, some obligation because reasons. How is it possible the parents had duty to protect, but the school administrators did not? Who said the school administrators did not? Who said the school administrators did not? All that we know is that the administrators weren't charged, which, prosecutorial discretion. Nor can the court conclude that Crumbley owed a legal duty to the victims based on the fact their son was a shooter. Michigan law is clear that familial relationships in and of themselves do not give rise to a duty-imposing special relationship. Typically, courts are reluctant to find any family member liable for an adult assailant's actions. Well, this isn't an adult assailant because thankfully we've already had that issue cleared up by members of the chat, so we can blow that issue completely apart. And that's the end of that argument, and we don't need to consider any further arguments because, that issue's already been resolved thoughtfully by the chat. So we can move on to the next paragraph. Despite the fact that the law recognizes no legal duty as to Crumbley and victims of the shooting, the prosecution proceeded nonetheless on the theory that Crumbley had a duty to control her minor child so as to prevent the minor child from intentionally harming others or to prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily injury. However, this duty is derived from civil cases involving claims of negligent parental supervision. Relying on relevant cases, again, address the duty of a parent to supervise or control their minor child to see a child's behavior does not involve danger to the child or to other persons. That case involved a claim brought by a mother whose 6-year-old was hit and killed by a car on defendant's fairground property. Defendant sought to name the decedent child father as a non-party at fault when the trial court denied. A jury ultimately returned a verdict in favor of the child's estate, and defendants appealed. The Court of Appeals reversed the jury verdict and faulted the trial court for striking defendant's notion of non-party at fault, naming the father as an additional negligent party. In reversing the lower court, the Court of Appeals reasons that parents cannot allow their children too young to understand danger to wander unattended. Rather, parents, as persons with special dealings with children, are expected to provide care and protection. In expounding on the parental duty, the court went on to hold that parents are expected to exercise reasonable care to control their minor children and provide instruction and education to ensure the child is aware of dangers to his or her well-being. Viewed in the context of these authorities, it's abundantly clear the parental duty to control the minor child has been applied only in circumstances in which the child was unable to appreciate the risks or dangers of the action or environment. This duty has never been applied in circumstances involving a teenager who commits an intentional criminal act. That's very true. Because the Crumbley was under no duty to control, we don't have to keep arguing about it in chat. We've already resolved the issue, remember? At the time of the shooting, Miss Crumbley was under no legal duty to safely store the firearm that her son accessed and used to commit the murders. Nor can Miss Crumbley be held criminally responsible under prosecution's theory that she was grossly negligent by storing a firearm and its ammunition so as to access the firearm and ammunition by the minor child. At the time of the shooting, Michigan law imposed no duty on Crumbley to prevent her son from intentionally accessing and using a firearm to commit murder. Since the Oxford shooting, the Michigan legislature has passed a safe storage law. Under Michigan's recently enacted safe storage statute, an individual like Crumbley could be held criminally responsible for failure to store the firearm as required under the statute. But at the time of the shooting, there was no such statute that criminalized gun owners' failure to prevent a minor from accessing and using a firearm to cause injury. Indeed, the legislative history makes clear at the time of the shooting, prosecutors lacked necessary tools to reliably convict an individual of an offense resulting from unsafe storage of a firearm. By enacting a law that requires safe storage, prosecutors will no longer have to prove elements of manslaughter or gross negligence that if they want to convict someone who's not stored their firearm safely. One argument proffered in support of Michigan's safe storage statute even mentioned specifically the Oxford school shooting. Testimony also indicated the mass shooter at the Oxford High School would not have been able to access firearms under the bill's safe storage laws because the shooter unlawfully obtained a firearm from his parents. As the legislative history has revealed, at the time of the shooting, there was simply no law in place which imposed a legal duty on Crumbley to prevent her sons from accessing a firearm to commit intentional acts. Despite the absence of any such law from which to impose a legal duty, the prosecutor charged her anyway, notwithstanding that Crumbley had not violated any statute nor committed any other crime. And the case law does discuss a gun owner's obligation to keep their firearms out of the hand of a minor and does so in the context of preventing accidental shootings, not intentional criminal acts. For example, the Court of Appeals has noted the law does impose on the gun owner special obligations to keep their firearm from their child, even a trespassing one, ready access. However, the special duty does not to tempt a child with firearm stems from the children's inability to appreciate the danger and inclination to explore without regard to the risk. In other words, their lack of adult judgment. As the case law made clear, our appellate courts have imposed a parental duty to prevent minor children from accessing firearms based on their inability to safely handle a weapon, rather than out of concern they might intentionally commit murder. To date, there are no appellate decisions on which a gun owner was found to have a duty to a third party where the minor child accessed and used the firearm intentionally to commit crimes. Foreseeable accidents were the concern, not intentional acts of murder. For as much talk as there's been about the charges in this case being unprecedented, and the first of this kind in its country, this should come as no surprise given there's no legal basis to charge, convict, or sentence Crumbley for the intentional crimes committed by her son. This was a sham prosecution grounded in prosecutorial overreach. Having committed no crime, the court should enter a judgment of acquittal. I tend to agree, for reasons we've discussed. Even assuming, for the sake of argument, that a negligent parental supervision duty were applicable here, Miss Crumbley nevertheless did not owe any legal duty to the victims of the shooting, given that the shooter was under the control and custody of the school at the time of the shooting. Because the school officials stood in the shoes of Crumbley's, under a doctrine known as in loco parentis, they and not Crumbley were the ones who had the legal duty to the victims based on the special relationship. Nice. Our Supreme Court recently explained the doctrine of in loco parentis as follows. The phrase in loco parentis literally means in place of the parent. A person in loco parentis is one who's assumed the status and obligations of a parent without formal adoption. That is, we didn't go through an adoption proceeding. We've recognized that at least one instant, at least in a limited sense, the relationship of a teacher to a pupil is that of loco parentis. Indeed, the common law doctrine arose in the educational doctrine context. I believe that's correct. I believe it did do that. A parent may also delegate part of his parental authority during his life to the tutor or schoolmaster of the child, who is then in loco parentis, and such has a portion of the power of the parent committed to his charge, viz. That of restraint and correction, as may be necessary to answer for the purposes of the employment. The power allowed by law to the parent over the person of the child may be delegated to the tutor or instructor, the better to accomplish the purpose of education. Yeah, nice. I like that very much. That argument makes me happy. It's like, not only did Crumbley not have the duty of a parent, the school actually had the superior duty. It's like, that's some good luring. I like that very much. The evidence at trial showed that Crumbley was summoned to the school by Hopkins for a meeting at which Hopkins and EJAC expressly told Crumbley that she did not have to take her son out of school. To the contrary, the decision made by the witnesses that Crumbley's son posed no danger or risk and that it would be better if he stayed in school around his peers. So they thought he should stay in school, and she conceded the point. Yeah, that's very good. That's a very good argument. Crumbley left the meeting around 10:50 a.m. The shooting began approximately 2 hours later. At the time of the shooting, Crumbley was not at school, and thus did not exercise any control or supervision over her son's actions. The absence of the control, custody, or supervision precludes any finding of parental duty on Crumbley's part to control her minor child. Nice. In the instruction to the jury, the court made clear that Crumbley's duty was dependent on the jury finding both she knew or had reason to know she had the ability to control her minor child, and she knew of the necessity and opportunity for exercising the control. She knew of and had opportunity for exercising. Based on the record evidence, Miss Crumbley could not, at the time of the shooting, exercise any control. The school officials, on the other hand, did maintain custody, control, and supervision. This observation led one of the panel members in Crumbley 1 to question why no charges were brought against Hopkins. And then they cite the Court of Appeals decision on this issue, right? The judge in the Court of Appeals, who's already sort of ruled on part of this issue, who said, while a prosecutor has wide discretion in deciding who to charge with a crime, I note that Hopkins conspicuously was not charged by the prosecution in this case despite encounters with the shooter the day before and the day of the shooting. Even a judge of the appellate court's like, this is a little odd to my eye. Yeah. The Court of Appeals judge questioning of why Hopkins was not charged based on the obvious observation that under the doctrine of in loco parentis, the witnesses, not Mrs. Crumbley, were individuals who had control and supervision over Crumbley at the time of the shooting, and it was the joint decision of the witnesses the shooter should stay in school with his peers notwithstanding the meeting. Nice. Accordingly, even if the duty standard taken from negligent parental supervision claims applied to Crumbley, her duty ceased when she entrusted her son to the supervision of the school. I like that. Generally, unless parents entrust their children to another person who agrees to assume the duty to supervise the child, the parent's duties to supervise continues. And then there's a case citing that the duty imposing a special relationship ceased to exist when the tortfeasor was no longer under control of the defendant. So, yeah, that makes sense. Other jurisdictions have applied the same framework in finding that parents cannot be held liable for tortious or criminal acts of their minor son, where the parent did not observe and was not in a position to control, citing a case from California. That case involved claims against a mother for failing to control their 17-year-old son who killed a man during the robbery of a bookstore, but the mother wasn't there. So, yeah. In Robinson, the court noted the general rule that absent a special relationship, an individual owes no legal duty to control the conduct of another person. Applying that rule, the court went on to note that the defendant's mother in California, like Crumbley, had no effective control of their minor son at the time of the shooting. The ability to control the child rather than the relationship is the basis for finding liability. Let's see, where were we? According to the California court, the key question under the relevant rule asked whether the parent had notice of their son's propensity to commit violent crimes, and if so, whether the parent had physical custody, control, and immediate authority, which, not so much. In affirming the dismissal of the claims, the California Robinson court also addressed plaintiff's claims that, like mother, Crumbley was aware of her son's numerous troubles, yet failed to obtain counseling for the boy. To this point, the court noted only the manifestation of specific dangerous tendencies trigger a parental duty to exercise reasonable care to control the minor child in order to prevent intentional harm to third persons. The Robinson court found that not only did the defendant's mother lack specific knowledge of the son's propensity for violence, but also that she did not exercise control or custody over him at the immediate times of the act. As such, the court concluded that the mother could not be held liable for their son's intentional acts. Under any legal analysis, Crumbley was not under legal duty, whether based on special relationship or otherwise. Simply put, without legal duty, they cannot be held criminally liable. I mean, that's what I thought, right? It's like there's no duty to these people. And it's an intentional act. It's an intentional intervening act, which breaks the chain of causation. So you've got multiple different problems on your underlying analysis, right? You have problems with duty, like I don't owe a duty to you. It's kind of hard to breathe. You got basically problems every single step of the way, right? I don't owe a duty to you at all. Assuming I do owe a duty to you, I didn't breach the duty because I wasn't there in order to breach the duty, right? So it's like I have a duty by controlling my minor kid. First of all, no, I don't. I have no duty. Second of all, even if I did, I wasn't there. How could I possibly have breached my duty? I gave control to the school, like parents do every single day, all around the country. I did a completely normal thing. I gave control of my minor child to the school. I wasn't there, so I didn't have a duty. I didn't breach the duty. Assuming I did. Causality. It was the minor child's intentional acts, their own independent. You charged them with intentional murder and you convicted them, right? It was their intentional independent acts. The independent acts normally break the chain of causation, right? So you have problems on causality and you have problem on damages. It's like, I didn't do anything that caused damage. So basically every single step of the analysis you fail. I had no duty. I didn't breach the duty. Causation fails and there's no damages. At least attributable to me. So basically every single step of the analysis you fail. I'm like, yeah. So pick your favorite reason, right? It's like pick your favorite reason. Do you like the reason that I don't have a duty at all? Do you like that they had the duty because they were now in supervisory authority, and so I wasn't there, and I entrusted them to them? That wasn't the breach. It wasn't the breach of me entrusting them to the school. That wasn't the breach. That wasn't the irresponsible thing for me to do. It isn't like I left them with some sort of wayward, person. That was some sort of negligent entrustment. It wasn't some sort of negligent entrustment kind of thing. Like I left them with some sort of derelict. I left them in control of the school. It was an independent act by them, who you charge as an adult. And, so basically at every single step you fail. It's like, which of these reasons do you like best? I'm like, yeah, I'm kind of with you, man. I'm kind of with you. I don't know. Maybe the Court of Appeals will dig its head out of its ass, although that's pretty unlikely because the Court of Appeals is going to be bound by itself probably. It's going to take the state Supreme Court to fix this shit, assuming they're going to, which I don't think they're going to. I think the Crumbleys are going to prison. I don't think the state Supreme Court is going to save this shit. I think they're perfectly happy with the stupid. And they're just going to pretend and just wash the whole thing away. And then just watch this become a precedent that gets cited and cited and cited and cited. You're walking on a bad path, my friend. You're walking on a bad path. Abort. They're not going to do it, though. They're going to ram this all the way through and be like, well, school shooting bad. I'll tell you what, man, they're not going to do it. They're going to have like a 4-3 decision someday upholding this thing. How many people sit on the Michigan Supreme Court? I'm saying 7 for the purposes of this joke. There's going to be a 4-3 decision by the Michigan Supreme Court someday upholding this. Probably under a fractured opinion for multiple different reasons. They won't even be able to agree as to why. By the way, did anyone else see that Justice Ketanji Brown Jackson was in a play like Broadway? Did anyone else see this? Did you miss this memo? Did you guys miss this memo? Ketanji Brown Jackson was in a play. She wanted to be a musical star. Hold on. One moment, please. We're taking a diversion. Talk amongst yourselves. Yeah. Oh, here it is. All right. Yeah.
Female empowerment. Sick. I like it too. I think what I like about it is that I am having a very strongly negative reaction to it. Like I hate it. Which makes me think it must be brilliant. Got this feeling in my body. Can't stop the feeling. Got this feeling in my body. I can't stop the feeling. I did it. I made it to Broadway.
Thank you. That wasn't intentional. My microphone is still doing weird shit. I need to go to Best Buy and get a new interface. I need to do it after the stream. I need to go and just pick up a new interface. I don't know. Every once in a while, it just does weird shit with like problems. And it's like, I don't know what the problem is. I don't know why it's a problem, but I need to replace the interface. So if any of you guys would like to super chat around 150 bucks, now would be a good time to help buy a new interface, because my interface seems to be being a little flaky. And so I think I'm going to get the Elgato interface and see if that helps. So, maybe I can set a super chat goal. Let's see if I get, so I need like 30 chats. Let's see. Okay. And then what do I do? In the next like 45 minutes, I can has new mic interface. Okay. All right. Let's see, where were we? Under the Michigan Constitution, an accused has the right to a unanimous jury verdict before finding guilt. In order to protect the defendant's right to unanimous verdict, it is the duty of the trial court to properly instruct the jury regarding unanimity requirements. Despite these constitutional requirements, the Crumbley's right to a unanimous jury verdict was violated, such that they're entitled to a new trial. Here, the prosecution proceeded at trial on two factually distinctive alternatives of involuntary manslaughter. Specifically, the prosecution argued that Ms. Crumbley caused the victim's death by gross negligence arising from the storage of the gun used in the shooting, and that Crumbley had a legal duty to control her mild child so as to prevent him from harming others. The court went on to instruct the jury it's not necessary that you all agree as to the theory that's been proven, as long as you agree the prosecution has proven at least one of the theories beyond a reasonable doubt. In a recently issued opinion, the Court of Appeals considered the same issue presented here, that is, whether the court was required to give specific unanimity instructions when the prosecution proceeded on alternative theories underlying a charge of involuntary manslaughter. Thank you very much, Al Ban Feinstein. If you have a Guitar Center nearby, go there. They know way more about audio to the Canadian computer connections than Best Buy. Thank you very much for your super chat. I mean, it's just a simple issue of getting a different interface. I mean, but I appreciate the super chat anyway. Thank you very much. Here, the prosecution's alternative theories of involuntary manslaughter were based on factually distinctive evidence. For instance, the prosecution's theory relating to gross negligence, storage of a firearm and ammunition was predicated upon evidence about where and how the gun was stored. By contrast, the prosecution's alternative theory that Crumbley failed to control her mild child was based on evidence relating to what Crumbley could have done to control her mild child. Those proofs include testimony from her boss that she could have worked from home that day on the school shooting if she would have taken her son out of school. Similarly, the prosecution argued that Crumbley could have taken her son to a same-day mental health treatment center like Common Ground. The necessary proofs underlying these alternative theories were factually and materially distinct, such that a special unanimity instruction was required. In this case, the court's non-unanimity instructions were modeled after the Michigan rules, which is a standard instruction given in cases involving criminal sexual conduct involving one wrongful act with multiple aggravating circumstances. In those cases involving one criminal act and multiple aggravating circumstances, it made sense that the jury not be unanimous as to which of the aggravating circumstances existed, so long as the jury found at least one. Indeed, the commentary to the rule explicitly notes the instruction is intended for use where the prosecution's theory of the case is that the defendant committed one sexual act accompanied by more than one aggravating circumstance. But even in that context, still the jury must unanimously agree on the underlying sexual act charged, the act reus. In other words, the jury must find guilt on the underlying act, but does not need to unanimously find which aggravating circumstances apply, so long as the jury all agrees that at least one is present. The reliance was wholly misplaced and inappropriate because the prosecution proceeded on two factually distinct alternative theories as to the actus reus in the case. In such circumstances, the jury must be unanimous as to which alternative theories it finds before it returns a guilty verdict. In People v. Cook, our state court is held where the state offers evidence of multiple acts by defendant. Thank you very much, Mark Bass, for you don't know what an interface is. An interface is simply the thing that my microphone plugs into before it plugs into the computer. That's what an interface is. Like most microphones, my microphone has an XLR connector. That's the microphone that you see on stage. It's a rounded connector that has like 3 prongs inside of it. And, obviously most computers don't have that built in. So you need something that takes the XLR interface so that the computer can deal with it. And so the interface is the thing that takes the XLR input and converts it like to USB. That's what an interface is. It's the physical device that you plug into. And I think mine is funky. Now, there shouldn't be any reason that it's funky, but I don't know what else it could be. So I'm going to replace the interface and hope for the best. Thank you very much for your super chat. I have one of the most popular interfaces now. I have the Focusrite Solo 3rd Gen. A very, very popular interface. I've had that interface for like 5 years though. So hypothetically, there could somehow be something wrong with it. I don't know. But I've been having audio problems on and off for a while. And so replacing the interface seems like a reasonable thing to do. And so I'm going to replace it. So I could either replace it with the 4th gen, or I could replace it with the Elgato. And I think I'm going to replace it with the Elgato and see if that helps using a different brand. I use an Elgato for my mic stand. I like my Elgato mic stand, and I have an Elgato Stream Deck. Elgato makes good products. So I was like, well, maybe I'll try the Elgato interface and see how that works. Yeah. The Shure SM7B is outstanding, yeah. My microphone is not the problem. Yeah, my microphone is not the problem. The microphone cable is not the problem. It could be the computer itself. It could be something with the audio drivers, which I don't know how to fix. It could be something with the audio drivers built into Windows somehow that's fucked up some way. But I've noticed problems also with sound, like when I change browsers or change browser settings or open a new browser, sometimes it will fuck with the audio. So I don't know what that is. But yeah, I've noticed problems with the audio. And so it could be a Windows problem. It could be something wrong with the audio drivers. I just don't know how to fix that. It's like, how do I resolve that problem? I don't know. Too much tech talk. In People versus Cook, the Michigan Supreme Court held that where a state offers evidence of multiple acts by defendant, each of which would satisfy the actus reus element of a single charge offense, the trial court is required to instruct the jury that it must unanimously agree on the same specific act if the acts are materially distinct, or there's a reason to believe the jurors may be confused or disagree about the factual basis for the guilt. Here, the court not only failed to give a special unanimity instruction, but rather instructed the jury could find guilt even if the jury did not all agree as to the theory has been proved, as long as you all agree the prosecution has proved at least one of the theories. Without the unanimity instructions, it's possible to know if or how the jury voted to convict. There are a lot of knockoff mics. I bought it brand new out of the box from Amazon. And I even took it apart to check the wiring and stuff. It looks like an authentic product based on the wiring. Looks right. So yeah. I could upgrade to Windows 11. And see if that solves the problem. To the extent that the court finds Mrs. Crumbley by and through her counsel either waived or stipulated as to any efforts raised herein, the court should excuse any such waivers based on ineffective assistance of counsel. In People versus Randolph, the state Supreme Court explained that establishing ineffective assistance requires the defendant to show that trial court's performance was objectively deficient and the defendant's prejudiced the defendant. Prejudice means a reasonable probability that but for counsel's unprofessional errors, the result of the proceedings would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. To the extent the court finds that the Crumbley agreed to waive, stipulate, or acquiesce to any of the errors raised herein, the court should excuse such waiver based on ineffective assistance of counsel as the following errors: failure to raise meritorious defense based on lack of recognized legal duty owed by Crumbley to the victims of the shooting caused her to be convicted of non-existent crime, which I think that issue's been pretty well litigated, but okay. Failure to raise a meritorious defense based on prosecution's inconsistent theories, which resulted in denial of their right to due process and fair trial. Failure to request a specific unanimity instruction relating to the prosecution's alternative theories of the liability for crime. As to each of these claims of ineffective assistance of counsel, the court should note that these claims are not grounded in counsel's strategic decision-making. Rather, the claims are based on counsel's failure to raise meritorious arguments and defense for which is controlling law that supports each defense. Each of these arguments and defenses would have been dispositive for the cases set forth herein. There's no strategic justification for failing to raise meritorious defense that would have resulted in dismissal of the charges. Accordingly, to the extent that trial court agreed, acquiesced, or failed to raise these issues, the court should consider the issues under claim of ineffective assistance of counsel. Windows 11 sucks? Yeah, I believe it does. And that brings us to the end of the thing. So, my friends, I don't know. I mean, I still think the duty issue is the most pertinent for me. I still think for me it's the duty and lack of duty and that being of the problem. It's like I have no obligation to these people, and I had no control, and I didn't breach my non-existent duty anyway. You know, there was no safe storage requirement imposed by law, so I didn't breach the non-existent law. This is an intervening act by someone else. So all those things, you know, that's sort of what I think. So yeah, that makes sense to me. That makes sense to me. So I expect the Court of Appeals to, rule against Crumbley on these issues, and then it's up to the state Supreme Court to see if they want to fix the issue. Which I wouldn't bank on it. Wouldn't bank on it at all. So, yeah. On personal news, I did do my elliptical today. I only did like 1.8 miles today. I've been trying to increase my count. Yesterday I did 2.2. So I was trying to go for 2.3 today, but I got kind of tired. So I only did 1.8 today. I didn't quite make it the full distance. But I did what I could, and then got tired. But I did 2.2 yesterday, and I did 2.1 the day before. I've been trying to increase every day by like a tenth of a mile. I've been trying to increase every day by a tenth of a mile. So I was supposed to hit 2.3 today, but I crapped out at 1.8. So, I'm going to replace the interface. I'm going to go to Best Buy and replace the interface and see if that helps at all. And if it doesn't, I can always return it, right? So I get 30 days to return it. So if it fixes the problem, great. And if it doesn't fix the problem, then, well, on to something else, I suppose. Anything else before I close the chat? Doesn't seem like there's a lot of commentary today. Best Buy charges a restocking fee. Yeah. You love my eyes? That's nice. Thank you. Have I seen a Brady dismissal? Well, I don't do criminal law, so I've never seen a Brady dismissal. But if you're saying, have I seen a Brady dismissal in a case, the only Brady dismissal I've seen was with Alex Baldwin. That's the only time I've seen a dismissal. Normally, the Court of Appeals reverses and sends it back for another trial. Normally the remedy is we give you the discovery and go back and try again. So that's the only Brady dismissal I can think of in recent memory. Recovery Addict does know a lot about audio. That's true. Yeah. I'll bug Recovery Addict. That's a good point. I'll bug Recovery Addict. All right. I'll text Recovery Addicts and see if he can help me out. All right. I'm going to talk to you guys later. I love you lots. Bye for now. Who's my favorite liberal Supreme Court justice? Well, the current court, probably Kagan, although she drives me crazy every once in a while. But Kagan is probably the most level-centered and most well-educated and most well-reasoned of the liberal members of the court. If you wanted to go back in time, like maybe Marshall, or Brandeis. Brandeis is cool. Brandeis wrote one of my favorite opinions of all time. Conservative members of the court who drive me crazy. Thomas sometimes. Sometimes Thomas drives me crazy. Every once in a while, I read an opinion by Thomas, and I feel like he defies his own principles. Maybe I just don't understand his principles very well. But every once in a while, I read an opinion, and I'm like, I think Thomas should be going exactly the other way on this issue. And so Thomas drives me crazy every once in a while. I guess Kavanaugh drives me crazy because he's a little too statist sometimes. My favorite, of course, is Gorsuch. Yeah. Of course, there's also like greatest of all time might be someone like Oliver Wendell Holmes, despite the fact that he wrote some really horrible stuff when it came to the mentally challenged. He wrote some really horrible stuff, like in Buck v. Bell and stuff. That was Oliver Wendell Holmes. And Skinner versus Oklahoma, that was Oliver Wendell Holmes. So he wrote some really bad eugenics supporting opinions. But he also wrote a lot of very interesting stuff in the constitutional history. Yeah. Yeah, but my favorite opinion, my favorite justice right now is Gorsuch by far. Gorsuch is my man. And for that, I still point to Bostock, because I thought his Bostock opinion was so brilliant. And it was a very interesting opinion with Gorsuch versus like Kavanaugh and Alito on like which is the more conservative way to read the civil rights statute. It was like, yeah, but I really liked Gorsuch's opinion in Bostock. That was the gays in the workplace case. And I thought his analysis was absolutely brilliant. Some conservatives really hate it. Some conservatives really hate it, but I thought it was brilliant. Have I ever met any of them in person? The only person I met in person was Ginsburg when she was still alive. I haven't met any of the current ones. I met Ginsburg when she was still alive. She was nice. She was really frail even then, though, of course. But she was very nice. All right, I'm going to sign off. I'll talk to you later. Bye-bye.